Well, here we go again. Thank you for your patience. I'm going to basically read the text that I've written because otherwise I'm going to be rambling all over the place as I often do, especially from my lecture days, which have been over for a few years now. But anyway, I'm going to basically read so you can tune out the visual if you wish, but here it goes. This is Putin's International Crimes in the Ukraine 101. So the basic course in what are the crimes that Putin can be accused of committing. By invading Ukraine and the actions of Vladimir Putin and the Russian military forces under his command, Putin can be accused of committing many international crimes, which are found in the body of public international law. Specifically, these crimes are designated as international crimes under international humanitarian law and are part of the international criminal law, the body of international criminal law. They arise under what is often called the law of armed conflict. This is formed by the joining of what are known as Hague Law, or the Hague Stream, and Geneva Law, the Geneva Conventions and their protocols. So Hague Law and Geneva Law form the bulk of the law of armed conflict. While most persons have heard about the Geneva Conventions, most people are unfamiliar with the Hague Law, which is based mostly on the 1899 and 1907 Hague treaties that some countries have ratified, but it's become part of customary international law. Hague Law mainly deals with the rules of conduct of hostilities, how you fight a war, and establishes limitations or prohibitions of specific methods and means of warfare, certain ways you can engage in armed conflict and cannot. Humanitarian law, for the most part, protects victims of armed conflict. That's the main part of humanitarian law, is protecting the victims, those who are harmed by war. Soldiers in the field, soldiers or sailors at sea, prisoners of war, and persons in military occupied territories. Those are the four major areas that are covered by the Geneva Conventions. There's First Geneva Convention, Second Geneva, Third and Fourth. The first is soldiers in the field. The second one is at sea, sailors, military that are out at sea. The third one is prisoners of war. How do you treat prisoners of war? And the fourth one is people who are under military occupation and what the occupying forces can and cannot do. These norms are established either by treaty law in what we call conventions or treaties, which are contracts between two or more countries which are governed by international law, or by customary international law, which I just mentioned, which is established by the consistent practice of countries, which we call states here, over the course of time, and that is being done with the understanding by the states that this is an international legal obligation. We give it the term opinio juris. It's the opinion of the country that the law is the way this consistent custom based on state practice has been established or crystallizes or ripens. We should use the term armed conflict instead of war in the field of the law of armed conflict, which includes the Hague Law, Geneva Law, and some of the laws and customs of armed conflict. War is a legal relationship between two or more countries, not the existence of armed hostilities. We will still use the term war crimes for certain violations of humanitarian law because that's the usual usage. But we now talk about not the law of war so much as the law of armed conflict, because war, again, is a legal relationship and not the existence of bullets flying and bombs dropping. The law of armed conflict has two main normative branches. One is called the jus ad bellum, the Latin phrase. It means the right to go to war, the right to use military force in the international arena. The jus ad bellum governs when and under what conditions armed forces can be lawfully used by a country against an opponent in the international arena. The second part of the law of armed conflict is the jus in bello, which governs how a military power can conduct its hostilities and how they treat victims. So the jus ad bellum says, can you go to war? Can you do this invasion? The law of jus in bello is, okay, once you're in a war, how do you fight it? How do you treat victims? What weapons and methods and means can you use? Can you drop a nuclear bomb, etc., etc.? So those are the two branches. Putin can be accused of violating both of these branches, as well as many other international legal norms, and in both a global and regional legal context. There are certain international treaties that he's violated that are global, and other treaties that are regional that he has violated, some of which are criminal, some of which are not. For example, the European Convention on Human Rights. And by the way, Russia was just kicked out of the European Convention on Human Rights system, and for good cause. So Putin can be accused of violating both of these branches, jus ad bellum and jus in bello, as well as many other international norms. The scope of this essay is limited to the 4 major international crimes that are raised by most of the information that we've seen available to us, mostly on TV, on our cell phones for reports on the war in the Ukraine, what's going on. So if you've been following that, you've seen horrendous things that have been happening, horrendous loss, horrendous expense of destruction of buildings, loss of human life, horrible, heinous, barbarous acts, and a whole lot of money being spent on weapons to the Ukraine to help it survive that could be used for hospitals and schools and for helping feed people adequately. Now I'm going to give you the background of this field of public international law and the law of armed conflict and international criminal law. Because what we're talking about is Putin violating international criminal law. Like in California, we have the code for committing lewd acts. That's a particular norm that's in the penal code. And so if you commit the act, then you can be prosecuted under that particular law. At the international level, there also are particular laws, which we call norms, some of which are criminal norms. There exists in the field of public international law a body of criminal law norms. These define international crimes and procedures. These crimes establish, quote-unquote, individual criminal responsibility for persons who commit these acts, and sometimes responsibility for those who are legally in charge of those who commit them. So we're going to say that Putin is responsible for what happened to these people, his own people, the military, committing certain acts in the Ukraine, even though he was in Moscow. So this latter vicarious basis, that is to say, you can be responsible just because of your relationship to those who are doing the acts, is called command responsibility. So both for civilian commanders, heads of state, or military commanders, under certain circumstances, they are responsible for the international crimes committed by those underneath them, the sergeants, the privates, the corporals, the generals even. Okay? This is called command responsibility. This is about imposing personal individual accountability and punishment for all those who violate the international norms or cause others to violate them, or who fail to punish those who are culpable, who are under their authority. Conceptually, an international crime describes an offense which is deemed so serious that it is an offense against and an injury to all humankind, the whole world. Examples are genocide, torture, slavery, for examples. It is accepted by the international community, of which the U.S. is part, that